the details usually escape people, right? I mean, there are details about trademarks that are important and that small business owners should know and founders should know. But this really was an opportunity to get sort of a baseline level of understanding for people of trademarks and how they can benefit you in your business. So I'll tell you a little bit about myself. You know, I've been a lawyer since 2004. I worked in Metro New York for a few years when I first came out of law school. And I came down and worked at Smith Anderson, which is a big corporate and litigation firm in downtown Raleigh. That was where I really cut my teeth on startup law. So some of you have probably heard of Merle Mason. He's a startup lawyer in the area. He is one of the sort of deans of startup law in the Triangle. And he and I were the startup group at Smith Anderson for a number of years while I was there. He was my mentor and taught me a lot about really the importance of how to counsel early stage companies and getting down to what's important for small companies and entrepreneurs. I left to go part-time basically as a lawyer and raise 3 kids. My wife is a busy surgeon, so I needed to do the pick up and drop off and doctor's appointments and stuff. And so luckily I had a career where I could join and do some contract work for some other firms. So I had other good lawyers that I was able to work with: James Forrest at Forrest Firm, Jesse Jones at Fourscore. Those are a little bit of, and actually I work with Venus Lyles. You may have heard of her. So there's a fairly small group of lawyers who represent startup companies here in the Triangle, and I'm lucky to have worked with a lot of them. And that enabled me to start my own firm, so Fisher Corporate Law, just really recently this year. And another reason I was going part-time is that I have founded or co-founded these 3 companies in addition to another 1 or 2. And, you know, having worked with entrepreneurs for a few years, I really got the bug, right? And so that was when I first decided to start a company. I chose Small Cakes. It's basically a franchise, a cupcake shop. The locations that we founded are still there. They're in Woodcroft, the Woodcroft Shopping Center, and one in Parkside Town Commons in West Cary. And I founded and ran and was I did baking, I did marketing, I did everything for that company for about 2 years. We sold it about 5 years after we'd founded it. And the woman who bought it still owns and runs both of those locations. She made it through the pandemic, which was great to see. Square Plum Custom Closets. It was my closet company. I'm a kind of DIY guy. I like to work with my hands, and I installed closets in my own house and then got friends saying, hey, can you do closets for me? So I ran that business for a little while, started and ran that business. I'm not working in that right now because I got interested in a software solution for helping small businesses start their companies, which is Startomatic. And so I founded that company, a SaaS business for entrepreneurs about 2 years ago. That was definitely built, and we had an office here in the Frontier. I put up my, these companies and firms here, not just to go through my resume, but also because I want you to notice how many trademarks are on the screen in front of you, right? So every company has a logo or trademark, and I'll talk a little bit about the difference between the two, but pretty much, right? There are very few companies that are going to exist without having some sort of identifier, either word or symbol or a picture or something that tells you what that company or identifies that company. I'd be willing to bet that every one of you has a trademark on you somewhere, on your clothes, on your bag, you're wearing it on the front of your shirt, right? If you're an adrenaline junkie, I don't see any obvious ones here, but you might even have like a Monster tattoo on you or something, right? From Monster Energy drink. I'm always like, I think about the guys who are at the ad agency or the graphic design firm that came up with that Monster symbol, and how they must feel when they see that people have tattooed it on themselves. I mean, this must be an amazing feeling of success, I think. So you're going to run into trademarks a lot. Today, we'll talk about what is and what's not a trademark. We'll talk about how you get the trademark and how much it's going to cost, because entrepreneurs need to be thinking about the bottom line all the time. And a little bit of extra trivia and stuff about trademarks on the top. So if you want the lawyerly part, if you were in an intellectual property class in law school, here's what you would be reading at the beginning of your section on trademarks, right? And this is from the US code, so federal definition of a trademark: a word, name, symbol, or device, or a combination of those things that distinguish your goods from the manufacturer, you as the manufacturer of goods from someone else who's manufacturing goods, or indicates the source, so where they come from, right? It's a little dry. So let's break it down in a little bit more plain English. So the trademark tells you who makes or sells the things, the stuff, the notebooks, right? The computers, the chips, whatever it is that you're buying. And goods is the lawyer's term for physical stuff. Okay. I'll talk about services in a second also. So the trademark itself can be a word or a phrase, right? It can be a symbol, or it can be a combination of words and symbols. Those are basically what you can have as a trademark. You all know this well-known, relatively well-known apparel company, I'm sure, and they have trademarked the phrase, just do it, just the phrase, not the font, not the color of it, just the actual words, just do it, in connection with their sale of shoes and clothing. They've trademarked the swoosh. They've trademarked their name, Nike, with the swoosh. Okay. And they have, I don't know, probably 1,000 other trademarks also. Big companies tend to have a lot of trademarks. So again, just a little semantics. Goods means just stuff that you can touch and feel. Services are typically, specifically, you would say a service mark if you're talking about services, right? So if you're a law firm or a CPA firm or a software developer, you would get a service mark, but everybody just calls them trademarks or even just marks. So that's what I'm going to say for the presentation. But just so you know, there is a legal distinction between trademarks and service marks, but it's relatively meaningless. Okay, so what is a trademark? So more than one company can own the same trademark, all right, which is an interesting concept to a lot of people, I think. This company sells trips on airplanes, right? That's what they sell. Then yes, exactly. I was going to say, does anybody know what this company sells, right? And they sell faucets. You all probably have a Delta faucet, or a lot of you have a Delta faucet in your house, right? Anybody know what that company sells? What's that? There is a Delta Dental also, yes. And I'll tell you that that's not them though. So if you like woodworking or home improvement like me, they make saws. Yeah, they make tools, like woodworking tools, like nice ones. Like I wish I had a Delta table saw. Anyway, how is it that all these companies can have the same trademark? And let me just point out that while I'm showing, those are obviously distinctive from each other because they have different designs and fonts and everything, but each of those companies has also trademarked the word Delta itself, just the word, okay, for their company. And the way that they can each own the trademark in the word Delta is that they each sell different things, okay? They're in different classes of goods or services. So that's how they can exist. You get your own little fiefdom of, trademark protection over the stuff that you sell, and someone else can get the same trademark in their little domain, okay? There are like 3,000 Delta trademarks at the USPTO registered. Some of them include sound pedals, sound effects pedals for guitars, lab instruments like a mass spectrometer, cognitive behavioral therapy, and horseshoe nails. Right? Who knew? Yeah. Yeah.
Can I just open up like start a car brand and call it like Nike car brand if I wanted to?
So yeah, maybe. Yes, actually, Nike's actually for a car, it's pretty distinctive from what Nike actually sells. But there are some brand names that have become so ubiquitous that there is, and this is a theme throughout trademark. There is subjectivity in determining whether or not a mark is infringing on another mark. Okay, and so could someone say you are only forming Nike car company because you want to derive some benefit from the goodwill that Nike as a company has? That's going to be a tougher one. So, and Nike is also going to sue the heck out of you, right? So, so you could try that, but I wouldn't recommend it. Okay, and so yeah, legally speaking, you're probably going to lose that fight. But yeah, yeah. Yeah, so there are laws that's a little bit beyond our scope here, but there are the right to your own brand, basically, or use your own name. A court though will still look at, are you trying to gain some kind of improper benefit by, even though your name, I don't know, yeah, if your name's Nike, right? Are you trying to derive some, peel off a little bit of their success for yourself, right? Without having built it yourself.
I was always interested when you see like the Michael Jordan Nissan. I'm like, like how did the thing, but I'm assuming the guy
Well, so no, I think Michael Jordan owns that, right? So I mean, that's a lot of these stars that I think they put money into these. I mean, that's like what they do when they retire. A lot of them is they invest in car dealerships, right? So what's the new one? It's a baseball. Yeah, Reggie Jackson has a new one, right? So I think that's part of, and I think there's a whole system. They may just license their name to the dealership, you know, it's not like they're out there you know, hawking Mercedes, yeah, I think that's with permission, because they also have the jump man on the thing, I think, right?
Well, the one I seen didn't. Just
Oh, okay.
you know, Jordan, I was like, I mean, it didn't seem like it was actually Michael Jordan.
Yeah.
It seemed like-
Oh, maybe there might be, yeah. So you do have some rights to use your own name. You will, if they tried that, if that's not Michael Jordan, they probably also got sued and must have had to win if they were going to make it work. Let's talk about the two main categories of trademarks. Trademarks are either registered or unregistered. All right. So let's start with an unregistered trademark. It's very easy to get an unregistered trademark. You just start using it, right? You just use the name or the logo and you put it on your stuff and you go out and you sell. The problem with that process and with getting an unregistered trademark is that your protection, your little zone of where you can tell people don't use this trademark because it's mine, is limited geographically, right? It's only the area that you are doing business in. So let's say you want to start a coffee shop and you want to call it Joe's Beans. You set up your coffee shop on the corner, you put a big sign up that says Joe's Beans and you start selling, but you don't register for a trademark. You have gotten yourself already a trademark, an unregistered trademark or common law trademark in the name Joe's Beans just by entering commerce with that trademark. But if someone sets up a Joe's Beans in California, you cannot go to them and say, you're infringing my trademark, right? Because you are here in North Carolina and that's the zone of your trademark protection is here or even smaller than North Carolina. Yeah.
This might be beyond the scope of this presentation, but to that point, if you started your business in another state with the same name, and let's say your business serves nationally, and you keep moving around, like I started mine in 2004, I've been in Delaware, I've been in California, I've been in New York, so, but I haven't registered. Does it then just become a locale here, like it's only in North Carolina?
Yeah, so I mean, you can build, if you are continuing business in those states, or if you still have a presence, or if you're selling to customers, or if you're advertising in those states, you could claim that, yes, even though I haven't registered this mark, I have a sort of a business presence and I have built some goodwill and there's public knowledge of my brand and my trademark, you know, in those states. But if you move your business and you're not really doing business there anymore, you've pretty much given up, and someone could start a business there under the same name and not really worry about you coming back to them, right? It's a good question though, because when we talk about registered trademarks, I'll tell you why you should register your trademark. Yeah. Yes.
Similar. So what if there are two small companies, same name, same area, delivering the same services, but one has an official business with an LLC established through the state and an E&I registered? How does the more official company approach the other one that they can keep their customers and accidentally take their?
So the question is, should I repeat that for, yeah. So the question is, if there are two businesses, small businesses in the same geographic area, and one of them is sort of a more official business, they've formed a legal entity and they're both using the same name, same name or same trademark, right? Same logo maybe, and maybe confusing to people. How do you go about approaching the smaller business? So the one critical piece that question did not include in the fact pattern is, do either of those companies have a registered trademark? So when we're talking about the right to protect your ability to use the name or logo, the first question is, have you registered it? And if you have, you are going to gain the ability to prevent anybody really anywhere else from using that name around the country, which is one of the major benefits of it's the major benefit of registering your trademark. In this situation, if we assume neither one of them has registered their trademark, it's each one of them probably has a common law trademark. And then you're going to look at, are they overlapping and who started using which one first? And is there definitely a likelihood of confusion between the two? Are consumers actually confused about which company they're doing business with? So how should you approach them? I wouldn't approach them at all first. I would submit a trademark application, a registration to try to get your trademark, and then I would maybe approach them after that. Okay, that would be the practical approach to that problem.
Small company. Facebook. Facebook have convinced themselves to. Is that possible about that?
Yep. I mean, if you're a small company named Meta and you have a trademark on Meta and you have registered your trademark in the social media or digital marketing or communications or any one of the many fields that Facebook exists in, you may have just won the lottery, right? So Facebook is either going to have to buy you or license the trademark from you, pay you a fee in order to use it. And that's probably what they did, because I'm sure there were a bunch of Metas, around. And so Facebook's team of lawyers went and dug up everybody that they could and said, and probably made an analysis, how much do we have to pay these guys and these guys and these guys? And then they wrote a check and said, we don't have to think about that ever again. So yes, you can get, but let's say you have Meta dog food, right? If you make Meta dog food, Facebook doesn't care about you, right? They don't have to pay you anything because they are social media, you are kibble. If you have an unregistered trademark, you can use the TM, right? So anybody, if you see the TM, it means trademark, but you don't have to do anything special for this. You can put it at, and you should put it after every time you're using your brand name, any realistic chance you can on your website. Even if you have an unregistered mark, that tells people, hey, I am paying attention to trademark stuff and I will protect my trademark. So don't mess with my trademark. Better still though, is to get a registered trademark, okay? So the registration is issued by the United States Patent and Trademark Office, federal agency. It has nationwide effectiveness, like I said. So it covers the entire US. When you get a registered trademark within your, if I have Meta dog food and I register Meta as my trademark in relation to dog food, nobody else can sell Meta dog food anywhere else in the country, right? And it's interesting, right? I mean, I could only be selling out of my little corner store in Wilmington, and I could stop somebody in California from selling Meta dog food and using that brand. The other major benefit to registered trademark versus unregistered trademark is, and this is a little bit, wonky, legally wonky, is that you get the benefit of the burden of proof, right? So if I own a registered trademark and I'm claiming that someone else is infringing my trademark, I go to them and say, stop using it. They don't stop using it. I sue them. When we get to court, they are the ones who have to present evidence that says, no, we're not infringing their mark. And they have to prove that they are not infringing my registered trademark, okay? If I only have an unregistered mark and I'm claiming someone else is infringing my trademark, I'm the one who has to prove it, okay? It sounds like a fine line, but that means the burden of proof is on me. It's like the presumption of innocence, right? It's who is presumed innocent in this trial, basically. So that's a big legal benefit to having a registered trademark if you end up in a dispute. The R in the circle is only for registered trademarks, okay? So that's the distinction. If you see the R, that means you've gotten a USPTO issued registered trademark. Yeah.
Register a trademark with WI.
I think so. I think that's an international trademark organization, and that's an area that I don't touch on much, and I'll talk about that just a little bit at the end. I don't know enough about that, the WIPO, to talk. I think it's the World International IP organization. The more protection you can put on top of your mark, the better. Although, are you just spending money to get, something that's not really going to get you any benefit in the long run? We'll talk about cost, but just a regular USPTO trademark gets you a heck of a lot of protection, especially for small and early stage businesses. If you were, yeah.
Do you trademark the name, the logo?
So that is up to you, right? And you can do any of those, right? You can do a word mark, or you can do a symbol, or you could do a combination word and symbol. My recommendation has been usually to start for most companies with just the words. Number one, it's easier to file that application, and I'll show you why that is in a minute. Number two, if you trademark Nike for your shoes, and someone else tries to use Nike, and then you start using Nike with the swoosh together. So, and then someone else tries to sell their stuff under Nike. You, just by having the Nike trademark, have already gotten yourself in a position to defend it against somebody who's using the swoosh symbol, right? The word is, to me, is sort of the fundamental basis of it. If you only trademark a symbol, then someone could change that symbol around a little bit. It's easier to get around it, right? They change the color of the symbol, because again, we'll get to it on symbols, what you have to include in your claim for your trademark. But you could make a little change to it and then sort of get around that trademark protection and start taking basically some of the value. And again, this is what we're talking about here, right? Is building value and goodwill in your brand, in your mark. And so someone else can start taking some of that away with just a little bit of a change. So I would start with the word is my general advice about that. So we talked about the fact common law trademarks are what you call an unregistered trademark, and that's because the whole idea of trademarks arose before any legislation came out to protect trademarks. People would create their own trademarks, on it as far back as ancient Egypt and China, and put them on their goods to say, this is my good quality stuff, don't buy it from me, don't buy it from somebody else. And so courts, especially around the time of medieval Europe, started enforcing people's right to use their trademarks and to punish people who were using other people's trademarks. I see a lot about wine. Apparently, your source of your wine is very important in medieval Europe, and so there was a lot of, I think, people stealing trademarks and trying to pass their goods, their inferior wine, off as someone else's good wine. We'll talk briefly about what's not a trademark. Just again, this is something we're sort of not covering here. Patents are not trademarks, right? So, from a patent is an invention, a development, right, that is distinctive from any other invention in the past. So the Wright brothers plane, obviously, the sublime, to the Lego brick, maybe even more sublime, right? 1951 was the Lego brick patent, which I thought was pretty cool. But I think you guys, patents are generally machinery or things that function tangible items as compared to a trademark. Copyrights, also not trademarks. And these are the three main categories of intellectual property, right? Trademarks, patents, and copyrights. And there are others, obviously, but these are the ones that you might think about. So Mozart's, compositions, Douglas Adams' Restaurant at the End of the Universe. So works of authorship, original works of authorship are copyrighted. And that's a whole separate body of law about protection of your copyright in your original work of authorship. Some other stuff, not a trademark, and this comes back to a question that was asked from the live feed. Forming an LLC or a corporation or any other legal entity at the state level, you have to choose a name, obviously, right? And you submit your articles to file it, to form it with the Secretary of State. That does not create a trademark, okay? That does not create really any rights in that name, except to prevent someone else from forming a legal entity in the same state using the same name, okay? And that's really administrative, it's not for brand building purposes. You have a lot of companies that are formed under one legal name and then never use that legal name in their public facing interactions, right? It's not a brand. It's not something that they need to protect from other people trying to take the goodwill of that company. And so that's a good thing to know, right? Is that you can form your company. So Small Cakes, the cupcake bakery that I formed, this is another lesson. We spent way too much time talking about what to name the LLC, right? We already knew what the brand was, but me and my two partners, it was our first business together. We talked for a long time about it and we ended up with Nom Nom LLC. It's the sound you make when you're eating a cupcake, right? Nom Nom Nom. We never used that name in anything public facing. Obviously, the whole company was Small Cakes. We had the logo from the national brand. And so someone else could have started up Nom Nom Cupcake Bakery and done that, without a problem. Our legal entity doesn't provide any protection for that. So that's not a trademark, okay? DBAs are a little different. You file for a doing business as. It's a business name that is usually more of a brand. You file it at the county level, usually. And you usually only file for a DBA if you're going to use that as a public facing branding mechanism for your company. So it's not specifically a trademark and it doesn't give you trademark rights. But if you take that DBA name out and start using it in commerce, you will gain yourself that common law trademark rights. The last thing that's not trademarkable are generic names. So coffee shop, if I want to name my coffee shop, it doesn't seem like a good idea, but if I did, I couldn't trademark that. And I wouldn't be able to stop somebody from opening up their coffee store next door and calling it coffee shop, right? Because it's generic. I can't trademark water bottle, right? And try to prevent everybody else from selling water bottles. So that's a good one to keep in mind. Do you need a trademark? We'll spend a little bit of time here. It's complex. Yes. No, it's not complex. You should get a trademark. Okay. You should either get if you've started your business and you're operating it in the public sphere, you have a trademark, you have a common law mark, but you should probably get a registered trademark is really the question I'm asking here. So how do you get one? The recipe for one unregistered trademark is short and sweet. You make your trademark, you use the trademark, and that's it. There's no step 3. Okay. So once you have put it out there into use, you have some basic protections from someone opening the same store next door to you and trying to profit from your hard work and goodwill. It's too easy. Yes, it's too easy because you get what you pay for. Okay. If you do it for free, it's really not going to get you the kind of protection that you probably want for your business. So this is a little bit more complicated. If you want to register your trademark, you make it, you go to your graphic designer, you go to, maybe you draw it up yourself, or you just come up with the words that you want to be your brand's, distinguishing words. You search to make sure that no one else is using the trademark. Okay. So this is important. And I've done it with all of my businesses, and you can do this on your own, right? You can do a Google search, you can do a USPTO search, and you can do Secretary of State's searches, all for free. Now I say search Secretary of State's like business registration databases at each state. Like I said, you don't get a trademark just by forming a company under a particular name. But if you see a company that's formed in your state with the same name that you are planning to use as your trademark, it's a good indication that maybe they're out there using that name as a trademark, and you should go check it. Okay, so that's just a good thing to search. The USPTO is reasonably user-friendly in its search. I mean, you can search basic word marks and you get a lot of results, and some of them are live and some of them are dead, and there are different categories, and you see who is the assignee of the mark, and there's a lot of information in there. You could do it yourself. That's part of the reason that a lot of people go to lawyers, is to help out with this process, or trademark processing firms to help. And so that's where it's going to cost you money. This is called a clearance search. And some companies charge, I think, the most I've seen for a sort of regular search is about $1,500 to do a clearance search. And 1,500, yeah. Now, other companies, big companies will spend a lot more. So they'll go out and do market research. They will search other business databases that aren't just available, through Google, right? They will spend a lot more time, right? If Target is going to introduce a new clothing line in their stores, they are spending hundreds of thousands of dollars on researching to make sure that that name is available and isn't going to cause a problem for them down the road, right? Because it has 100% has to be right. They cannot have a problem with it. For most startup companies, if you pick something that is relatively distinct from anything else, like a made-up word, right? If you pick a Google, not Google, but like Google, something that nobody ever uses for anything else, pick a made-up word, you will probably be fine, right? And you can do a couple of searches and find out, is anybody using this made-up word anywhere else? And if you don't find anything, you're probably good to go without paying somebody to do a search for you. Step 3, you submit your application. We'll talk about the application in a little bit more detail. And step 4 is wait. Okay, this is from the USPTO website as of June of this year. The first action is, so from the time you submit your application, it takes 8 months for them to even look at it. All right, so you get it there and you wait 8 months. Disposal, that means either they tell you it's able to be registered, or they're going to register it, or they send you a letter that says we cannot registering it. They make a decision on it, is more than a year. All right, so you've waited maybe in a year or more, a little bit more, you'll get your trademark issued. Now, this doesn't mean you should just forget about it, because why should I do it if it's going to take a year? You get the benefit of your application date. So your application date is the date that you submit your application. And if your trademark registers, then your coverage, basically your insurance coverage, is good all the way back to that date. So you get protection. You say, that was when this trademark was registered. Anybody using it since that date, I can tell them to stop. All right. USPTO, is an old agency, 1836 it was founded, has 622 trademark examiners. They are all lawyers, and so they are the ones who read the description that you write about your stuff that you're selling and the class that you choose and decide whether that conflicts. They processed 1 million trademark applications in 2019. And probably more since then. The pandemic saw a significant increase, you probably all know, in business formations and trademark filings and all kinds of business related activity. So they're busy. It's not, haven't done the math. I don't know how many they're looking at a day, but you can see that's why it takes them 8 months to actually like start looking at it and make a determination. Yeah.
So it sort of goes into, you talked about something being generic, but also sort of going up somebody's goodwill. Say, for example, there's a show on TV, Uncle Lucky's Farm. And Uncle Lucky's Farm is very famous for its overalls. So, the show's called Uncle Lucky's Farm, has, saying, doesn't talk about the overalls, but he's famous for his overalls. I'll start a company, completely unrelated, overalls, movers, like I'm saying, it's about a moving company, but, my whole basis is all our guys wear overalls. Like, I guess, where does that fall?
Yeah.
I have a similar situation. I started, I have a trademark logo, all that.
Okay.
It's based, there is somebody that drew inspiration, but I have another, that was definitely inspiration, but I have another reason for starting it and using it.
That's a good question. And so the question for the feed is, if you have someone who has a distinctive feature about how they are running their business in their presentation, so like overalls on a guy on a TV show, I'm thinking hee-haw, that gives you an idea of how old I am, but somebody that's, just part of who they are in their business, and that's how they present themselves to the public. People know them by their overalls, right? And then someone else starts another business that draws heavily on that overall theme and it tries to benefit from the goodwill that's been built by that original business. Where does this fall? So what you're asking about is trade dress, which is another one of those intellectual property areas that's separate. It's not patents, copyrights, or trademarks or trade secrets. It's trade dress. And so let's say you started a cola company and you're selling cola, not Pepsi, not Coke, not RC, and you use red and white packaging and you make a curve on it and you call it, I don't know, you just write cola on it even, but it looks like a Coke, right? You are infringing Coca-Cola's trade dress, which is sort of the overall feeling. Again, it's very subjective. The overall feeling that you see a can of Coke, and if you put another, red and white cola can with the, curve on it or something and similar font, even though it's not identical and you're not infringing any trademarks, you're infringing their trade dress and they will sue you for it. So that's what those overalls are that guy's trade dress. No pun intended, but that's trade dresses, how you've dressed up your brand.
So even if it's something completely like this is like a cartoon, so it's not like they're not selling anything. And like the design of the logo is different from the way, the way it is. It's like, does it in my mind, like I would think like, all right, well, overalls are a generic thing. I didn't, so say these overalls had, red and white stripes on. My overall kind of is generic blue overalls.
Yeah.
You know what I'm saying? It's just like, if it is not, it's not like a copy of it or, like, oh, like, is this a little bit different? It's like completely different. But the name is more so the name, like, oh yeah, they're called the overall group. I have overall movers, has nothing to do with what they do in the show. In the show they did moving, I'll get more, but it's like completely unrelated to that. They still could.
No, I think you're probably okay based on what you're telling me. It sounds like since you're in two different industries, right? Really, I mean, they're doing two different things, selling to two different groups. I think those are not overlapping trademarks. So I would say you're probably okay. I mean, you can borrow elements from other people's trademarks, right? You can't copy them usually, but you can certainly get inspiration from other people's trademarks, especially if you are in a completely different industry or class of goods or services for your mark. Yeah, then you're fine. Yeah.
Trademark technically don't have to be renewed, you just have to show them continuation. Why is it that since they're both federally granted to the country, do you have an opinion why trademarks are different than copyrights? I mean, why do you get to own it forever? Whereas a copyright just would have to work for a little bit, just like movies, they can be publicly given away. you don't maintain your copyright?
So the question is about sort of maintaining a trademark once do you get to keep it forever versus a copyright where you have to, you have to renew the copyright every so often. Trademarks, actually registered trademarks, you do have to renew the trademark. You pay it's $525. You pay it once every 10 years to renew the trademark. It's similar though to an unregistered trademark in that if you stop using it, your company goes out of business and you stop using it. That's why. So I mentioned when you search in the USPTO, one of the categories is live or dead. So all the marks are listed as live or dead. So that's what a dead mark is, right? Someone has abandoned it, and so that's actually the legal term for an abandoned trademark. And so when you go to file your identical trademark to an abandoned or dead trademark, the USPTO, I don't even know if they might try to contact the last contact person on that who owned that trademark, but generally you can get that trademark because someone else has stopped using it. So it's not in perpetuity, the ownership of the trademark.
So many companies hold that, they need to get the trademark. How do you distinguish between all of that? How could you get it?
That's, so the question is, how do you distinguish between the number of sort of trademark service companies out there that advertise to people as soon as you type into Google that you're looking to file a trademark? You get probably a lot of ads in your sidebar. And hopefully I'm educating you here about some of the things, what the process actually looks like. You'll know what it's worth it, whether you want to take it on yourself, whether you would want to hire one of those companies. I'd read the reviews about it, just like anything else, if you could find an unbiased review about those companies. And I'm biased because I'd say talk to a lawyer, right? And have them, give you the personal contact and personal review and what you get for paying someone else to help you with it, who knows what they're doing. And so I'll go through this a little bit about, you can see the process for yourself and decide, is it something I want to take on my own, or would I hire somebody to do it for me? 4 steps in the registration process. You apply, the USPTO examines it, the USPTO publishes it for people to look at, and then you get it, hopefully. The application is really the main part that we're concerned with here. 3 decisions you have to make, basically. Number 1, are you filing for a word mark, the standard character mark, where you just say, I want the phrase just do it, without any reference to color or font or anything else? Or do you want a special form, right? So am I filing for just do it, or am I filing for the special form? It's harder to file for a special form with the logo. You have to make a claim of color, exactly what color it is, where the color is located in the logo, what the orientation of the parts to each other are. It's just harder to write up, right? That takes some art to write up a description in prose of what the logo looks like. Number 2, you have to carve out your little area of what the trademark is protecting. So number 1, you pick a class or one or more classes from these 45 classes that exist at the USPTO level. There are 34 classes of goods and 11 classes of services. And so you have to pick at least one of those. You can pick more than one class to register your trademark in, but you pick the class and then you write up a description about what it is that your company does and what you are protecting with that trademark. And then the USPTO examiners will take a look at your description and they'll find somebody else. They'll look in the same class and they'll look for descriptions that describe something similar and make sure that if the logo or the name is the same or confusingly similar to an existing logo. So that's what the examiners are looking for. They're looking at what you said, what's your class, what's the specific description of what you're doing, and does the logo look the same or very similar to an existing logo, or is the phrase the same or very similar? 3rd decision, are you filing an in-use application or an intent to use application? In-use means you are using this logo, this mark actively in commerce now. You have sold, it's up on your website, it's on your letterhead, it's on the sign on the front of your coffee shop. You are using it in commerce. Intent to use is a little bit harder to file. It's not harder to file. The initial application is the same pretty much, but you have to follow up eventually to say within 2 years that you are actually using that mark in commerce. Okay, it's basically a reservation. So I'm going to reserve this trademark, even though I'm not actually using it in commerce yet. My advice is almost always, for most small businesses, wait until you're using it in commerce. It makes it easier, unless you really think someone's going to come in and scoop you out of your trademark, by filing before you, then maybe you file the reservation. Or if your business has a particularly long development time in R&D, then maybe you want to get the trademark nailed down first. But for most entrepreneurs, just wait until your website's live, you're up, file the in-use application. So after you get the trademark, after you file the application, the examination, a nice lawyer, hopefully nice, reviews your application. They publish it, right? So there's this thing called the Trademark Gazette, Trademark Online Gazette. I don't know because I never look at it, and only like trademark service firms and big law firms with big IP practices are the only people, and big companies who are looking to see if someone else is trying to infringe their mark. Those are the only people who look at that, right? You don't need to know about it, but it is public record, and you can go and look at all of the filed applications and say, oh, somebody's, trying to file another small cakes, and I'm going to stop them from doing that. I want to object to them getting their registered trademark. You get it registered, you do the happy dance, you get a piece of paper. This is a copy of my software company's wordmark, Startomatic. It's got a little seal on it. The paper is, it's nice to have, but it's relatively meaningless. But the fact that you are now listed as a registered trademark in the USPTO database is the gold. That's what you wanted to get, right? So now you're listed in there, live mark. You got 10 years until you have to renew it. How much does it cost? 3 types of fees you'd pay versus the clearance search we already talked about. You're looking to see, is my mark going to be infringing someone else's? Is it too close to someone else's mark? You do it yourself or pay a firm to do it. You're going to pay filing fees. And so this is where it matters how many classes you want to register your mark in. You pay the filing fee based on the number of classes that you choose for registration. Most clients, 1 class is fine. For most startup companies, you're really only doing one thing. I do have a client who has a podcast, and they want to sell clothing that has the brand on it also. So they have the name of the podcast. So I'm using 2 categories for them. 1, a service of entertainment, and 1, a goods of clothing. So we're going to pay 2 filing fees for them. But for the most part, 1 class is generally fine. And you're going to pay professional fees if you hire someone else to do it for you, right? And these can vary a lot. Maybe it's an internet service company, and they, charge you $79 or something. And again, you get what you pay for, and who knows how the write-up is going to be. Their description of your goods is important, and how much time they're going to put into that is questionable if you're paying, such a relatively small amount of money. Some firms bundle, their services. The bottom line is you're probably $250 for 1 class for a word mark if you do it yourself, right? You can probably get away with that. $3,000 plus if you're paying the search firm. If you're paying a professional, you can expect somewhere in the $1,000 to $1,500 range to pay a law firm. My firm, just for benchmark purposes, we charge $1,200 for start to finish. So including the filing fees for USPTO filing fees for 1 class for a word mark. I think, and I'm in the range, of what you would see in the area. We talk about the renewal fees, and probably only need to file in 1 class. Yeah, so renewal fee $525 every 10 years. Some topics that we aren't really going to cover here, but you can at least keep in the back of your mind. International trademarks, right? It's a whole separate system in every country you go to, right? Every country, the EU, I think, has a combined system, and I don't do much in the way of international marks. If you have a business that is going to be a huge global business, you will probably hire an international law firm to do the international trademarking for you, right? But for most of our purposes, for early stage companies, the US registration is plenty. States all have their own trademark registration. All 50 states, you could register a trademark in Nevada if you wanted to, in any of the 50 states. But it's pretty much the same process as the USPTO. It costs about the same. It may be a little bit faster because they don't have as many applications to process, but you get only protection in that state, right? So someone else could use, if you get a trademark in North Carolina, maybe you want to do that, but then someone in South Carolina could be using the same, could use your brand. You don't have any registered trademark protection there. Yeah.
So say you register your in North Carolina, somebody ends up doing it on the US scale. So essentially, I'm assuming you still be allowed to use North Carolina.
Yeah.
but you can't stop them from using it.
Exactly. So the question is, you register your mark first in North Carolina, someone registers the identical mark for the same type of goods or services nationwide with the USPTO. Are you prevented from using your mark in North Carolina where you have registered it? No, you still have good protective rights here if you filed your registration before that person filed their registration. So yeah, that's a first in time question. Yeah.
Negative. This is positive. It's not really cheaper, maybe a little faster. Why would someone? Do that?
I guess the revenue stays right with your state instead of the federal government, right? So, yeah, I mean, it's honest. I've never done one. I don't think I've ever heard of anybody doing one. If you are sure that your business is going to be a small, intrastate business for its entire life, and it's probably a little bit faster and maybe a little bit cheaper. But again, you're not talking huge dollars for federal registration. That's just why it doesn't generally make sense to me to think about a state registration. Yeah. An office action is what it's called when the USPTO sends you, instead of a congratulations, your mark is registered, they send you your SOL, somebody else is already, got this name and you can't use it. Then you can contest it, you can appeal it, you could sue the USPTO and say you're interpreting this mark wrong. So that's a whole process, right? And there are IP firms that do that for a living. Similarly, disputes, not with the USPTO, but with other people. I'm not going into this much, but we've talked about it a lot. The whole thing is about protecting your goodwill and your brand. And depending on how big your company gets, there are serious, real disputes about companies infringing other people's marks and IP. And so my wife had a concierge aesthetic medicine business for a while. And she called it, her website was Concierge Aesthetic Medicine. And we got an email, not a letter, but an email from a company in California that is Concierge Aesthetic Medicine and had the trademark and sent it to me. And I looked it up and they were right. And so we changed the website. It wasn't a big deal. It was a very small business, but cease and desist letters fly all over the country every day, all over the place with people who find things online and say, you're using my mark. So that's just part of the landscape now. I'll say a word about fair use. Fair use is using someone's trademark without their permission, but in a non-infringing way. So they couldn't sue you for it, right? So for example, you go on Amazon, you want to buy a case for your phone, and the advertisement on Amazon in commerce uses the word iPhone. It says this phone case fits the iPhone 13. iPhone is a trademark, right? It's Apple's trademark. They are still allowed to use that because they are just describing this thing. They are not trying to sell it. They're not trying to confuse you about the source of their goods, right? They're just being descriptive of this other thing that has this trademark. Similarly, a comparative statement, in an advertisement, people like In-N-Out 100 times more than McDonald's, right? In-N-Out Burger's way better. You can put that in your ad if it's either an opinion or it's not a falsity, right? You can't lie. But if it's just an opinion, you can certainly put that out there, and McDonald's can't sue In-N-Out Burger and say, you're using our name without our permission, our trademark without our permission. So you cannot indicate, though, that McDonald's has, approved that message, right? Or sponsored it. And you can't try to confuse people about who is putting out the message, right? Mildly interesting, always order your In-N-Out Burger animal style. If you've ever been out there, get it with animal style. It's much better. Yes.
If you are doing that, is it best or not best to add an R after the word McDonald's? I mean, how do you do it legally? Would you get in trouble for putting the R, or would you get in trouble for not putting the R? Does it matter?
If you are not McDonald's and you want to use their trademark, yeah, I would put the R there. Yeah, do put the R there. Yep. Yeah, better to put it there. I mean, everybody knows McDonald's is not a probably good example because everybody knows it's a trademark. But if you're, some other one, if it's a smaller, niche comparison you're making, yeah, the R indicates to everybody else that is a protected trademark. And so better if you're using someone else's trademark. This is a good question. The question was, I'm sorry for the streaming, should you use the R in the circle, the registered symbol, if you are using someone else's trademark for comparison purposes or descriptive purposes? Yeah. Yeah.
Let's say you're a small little company and you start growing. One thing you can do, of course, is create subsidies and trademark those. But let's say you grow really big, like on Amazon.com. Can they open up and add to their registered trademark if they want to move forward? Are they required to start new trading. With Amazon, for example, seems to have grown, and they do have subsidies, as does Google. But a lot of times Amazon seems to use their same website and trademark, and yet they mushroom. So how does that work if your small startup is successful and you start branching out and you want to retain it under that? Is it possible?
So the question for the streamers is a company that grows and has different branches and subsidiaries and different elements that they are selling. You know, can they continue to exist under the same trademark, or do they need new trademarks separately, but you know, under one combined family? Is that
Yeah,
sort of?
you have to, 'cause
Yeah.
You do have to be able to defend. You can't just take all the case, you know, all the different 49 or whatever categories. But if you start getting into some of those, that you want to be under your.
Yes.
trademark, is that possible? Can you go back and touch like an
Yeah.
enterprise license agreement? You can reopen it legally and add stuff.
Yes.
I don't know if you can under trademark.
You can. Sorry, so I misunderstood. The question is, if under the same trademark, if you start selling more and different things from other categories under that same brand, can you expand the coverage of that trademark? Yes, you can amend your trademark. Yep. So you can submit an amendment. You can do you can assign the trademark. It's like a piece of property, really. I mean, you can assign it to people. You can pledge it as collateral for a loan. You know, you can do a lot of things with trademarks. Yeah. I mean, it's a valuable piece of intellectual property. And yes, you can amend your trademark over time. So coming up on the end here. So we'll quickly go through. Here's what you should know. If I've done what I was supposed to do here, you should probably get a registered trademark. It will cost you $250 to $2,000, maybe. Pick something that is not going to cause you problem with someone else. There are lots of names out there, lots of made up names and lots of things that, you know, so just save yourself the headache. Don't try to do something that looks like it's going to be pick a fight with somebody else, and file it soon, and then be patient for it to come back, because it's going to take some time. Yeah.
If you do an amendment, does that restart the 10-year clock?
I don't know about the 10-year clock, actually. I think for the renewal, the question is, if you amend your trademark application, does it restart the renewal clock? I don't think so, but I don't know that for sure. That's relatively, if you're still using it in 10 years from now, you will probably know, you'll get the notifications that it's time to renew. And yeah.
So along the lines of your question is, if you're applying for the first time, you're looking at classes and you do like 3 or 4 things, but one of it you do 80% of the time, other things you just do a little bit here and there. Would you say just go for the first class and then amend it later if the other services or products grow?
Usually, yes. So the question is, if your business is in several different, operates within services or goods, sells goods within several different classes, should you just pick the one you do the bulk of the business in to start with? I would say yes, just pick that one first, unless you are aware of any specific threats to your trademark in those other small areas, right? If there's somebody else who's a competitor who has a name that's similar, or could be confused, then maybe it's worth spending. It's not that much more money, right, to spend it for that class of goods. Now, you do have to submit a sample. I think I actually didn't mention this in part of the application. You need to submit a sample with your in-use application that shows your trademark actually in use in commerce, right? So screenshots of websites work, pictures of the label on the clothing that you're manufacturing, your letterhead, stuff like that. You know, you can show that that's how I'm actually using my trademark in use. I'm sorry, I didn't mention that earlier. Yeah.
Business cards work.
Business cards. Yep. Generally those will work. Yep. Bass Ale, 1876. That was the first registered trademark, and that's obviously in the UK. And that's when they started their actual official registration system. Yeah, that red triangle. It's actually just the red triangle, I think, which is very cool. It's kind of like, I don't know how Target was genius. They got that bullseye, you know, that's like, how could you get just everybody? I mean, it's so recognizable, right? But that red triangle is a good one also. So yeah, thank you. Yeah. Questions? Yeah.
Since you put that up, I had a fun question. How would you contrast the bar exam between New York and North Carolina?
New York's was harder. Yep, New York's was harder. You're taking me back a few years now. I took New York in 2005. I took New York and New Jersey together, which they allowed you to do. They put the multi-state day, the multiple choice day in between, and you do your essay day for, I think it was New Jersey first, then you take the multiple choice day, and then the third day is New York. So they do that because a lot of people get barred in New Jersey and New York together. Yeah. Yeah. Okay. No, I am 90% sure the answer to that is no. And I've never had a rejection, which is a good thing to be able to say, I guess. But it's a, and I mean, I don't file 1,000, I haven't filed 1,000 trademarks, but I don't think so. The fee is for their time. Do you get your money back from, I guess, from the USPTO? Almost certainly not. They are not going to send any money back. The service provider also almost certainly not, because they put their time and effort into it. So yeah. Yeah. Oh yeah.
What I type article about McDonald's premises are premises, if I was writing about that.
Yeah. The question is, if you're writing an article, for example, about fast food restaurants and you include the name McDonald's, should you or must you include the R in the circle or R in parentheses after it? No, you don't have to. You're not, you know, it's probably better to, but you don't have to. No one's gonna, you're writing it, that's a fair use, you know, it's for educational purposes, or, you know, you're writing, in the media, it'll be fine. Yes.
I'm not sure how to phrase this question, but I had a friend of mine who got a great deal on the internet. Buy some fire pit with furniture and all this other stuff at a great price. And in the background was a Home Depot. So he thought he was buying from Home Depot. He was wrong.
Mhm.
So it's a question of Home Depot didn't defend their trademark. I don't know. Does he have a claim against Home Depot because he was fooled into thinking that he was buying from Home Depot? Or
No. Yeah, so the question is, a guy, somebody bought a fire pit online, and Home Depot was in the background of the picture of the fire pit, indicating that, or seeming to indicate that the fire pit was being purchased from Home Depot. Is there a claim against Home Depot for not preventing their trademark from being used in a fraudulent manner, basically? No, definitely not. You know, there's the answer to that question. The company that sold the fire pit is infringing Home Depot's mark. So Home Depot has a claim against that company, right, for infringing their trademark. And there's probably a consumer products claim by the trade commission claim, right, for the consumer who is saying this is a misleading advertisement for this product. And so that would be, you would complain to the Attorney General, and they would do nothing about it probably, but you could at least complain, you know, about it, and that's where the claim would be. And if it were a $500,000 fire pit, and it came and it was substandard, then maybe you'd have a claim that you could say this fire pit, you know, I thought it was being sold by the best fire pit manufacturer, but it was being sold by a fourth-rate manufacturer, and I want half my money back. Maybe there's something to be had there. In this case, that's a buyer beware kind of story, I think. Yeah. Yeah.
I don't remember, I may be getting this right confused. I don't remember if it's copyright, patent, or trademark, but fashion. That's why we can basically buy generic versions of designer fashion.
Yeah.
So if somebody, and not me, I'm thinking like by the client, but if somebody were starting a fashion company or a fashion line, none of that's protected, correct? They can only protect their name or their logo. They can't protect the design of the clothes.
You could protect the designer clothes. If it's novel, you could patent it, but it's kind of like a recipe. So people ask about recipes also. Could I patent my recipe or copyright my recipe? Yes, but if I say 1/4 of a teaspoon of salt instead of 1/2 a teaspoon of salt, I've now changed your process, and I'm outside of the patent. Right? Same thing with fashion. So if I alter the hemline by 1/2 inch, I've no longer taken a direct copy. Now there are, and I'm not an IP specialist, and that also gets down to trade dress, no pun intended again, but if you are consistently putting out, if you have a whole website that looks like Michael Kors' website, and you have shoes and dresses and everything looks like Michael Kors, they're probably going to say, hey, you are, you know, inappropriately infringing our goodwill that we have built in this brand by making people think and confusing the consumer to make them think that they're buying from Michael Kors when they're not.
That's where it goes from counterfeit.
Oh,
Go back and ship.
yeah.
Trying to
Yeah, so that's, I mean, that obviously I didn't talk about that, but yeah, if you put your Louis Vuitton mark on a bag, in Wuhan and send it over here, that's a federal crime. So that's a different crime. That's past trademark law. That's fraud. And yeah, there are federal laws against that. Yeah. Yes.
Because yeah, we can talk about that.
Okay. Okay. Yes.
So in my youth, I thought of myself as a poet. And someone told me that if you mail yourself a copy of your poem and the postmark was on a piece of paper itself, the poem is written on, you'd have proof of ownership, you had a copyright. Is that true?
So yes, it is true that you've given some proof of ownership. You get the copyright in the thing as soon as you create it, right? So as soon as you wrote your poem, the question is, if I mail myself a copy of a poem or other work of authorship that I make, music, sheet music or something, do I create a copyright? You haven't created the copyright by mailing it to yourself, but what you've done is provided future evidence if someone else uses the same poem or music is, if someone else steals your riff, you can say, here's my postmarked letter with the date on it, and now I've proved that I created this all the way back to this date that it is postmarked. So all you're doing is creating, a little bit of evidentiary file for yourself if you were to have a dispute in the future. The value of that, I think, is limited, however. So I would say you'd have to be pretty good and you'd have to be making a lot of money off of that. And then if you are making a lot of money off it, it's already in the, ASCAP system or whatever the people they use to distribute music or poetry, or it's been published in a book. And then you've got the publisher says, yes, this poem was already published here. You don't need it in an envelope to demonstrate that you owned it first or you created it. Yeah.
Anybody still use the service mark?
Yeah. Yes.
So if you have services, because I know a lot, like I was told you could use TM even if it's services, especially if it's your company name, but should you be using
SM? Yeah. Again, you are basically telling people, it's like a warning sign. It's like the sign out in front of your house, right? That says security system inside, right? We are paying attention to our trademark and our IP. Don't take this or we will come after you, right? And so yes, whether or not you use SM or TM, you're getting the same message across. Yeah. All right. Well, yes. Yeah. Okay. So it's optional, but again, it's preventative, right? It's telling people this is a registered mark, don't take it. Is that going to stop anybody? Probably not. Somebody who wants to steal it, especially in graphic design, I know it's a big problem. You put your stuff up online, your stuff can get taken. Finding out that someone has done that is a big issue, right? So you may never ever know about it, which is not right. But using the R at least tells people this is number one. If you're using the R, that means you've got it registered, right? So you've filed the registration and you're putting some time and money into protecting it, and that tells people that you're probably going to come after them if they try to appropriate it. Yeah. Okay.
What if I put an R in there and I really don't have it?
Yeah, that's I don't know, actually. I mean, you're probably false advertising to an extent, but it's not, I don't think that encourages the consumer to act differently. That's a good question. I think you probably would be okay. It's kind of like jaywalking, I guess. Yeah.
Take it off my phone.
Yeah, leave it on the poem. The poem you should, yeah. Okay, thank you, everybody. Yeah, thank you.